Our eNCA specialist reporter Karen Moore joins me in studio now. She was at the Constitutional Court as this judgment was handed out. Afternoon, Karen. Firstly, let's just talk about the collective of the various parties that brought this matter before court. What was it like today post the judgment?
I think there was a massive sense of celebration and relief because obviously I don't think we can underestimate the kind of trauma that this has inflicted on 10 million grant recipients. And you know, some of those people were in court today wearing their T-shirts, clearly concerned about the outcome. And I think that, you know, we can't ever forget that while these legal dramas have sort of political dimensions and, you know, we can analyze them as legal experts and politicians, really this is about the fate of 10 million people, and the devastation that this entire situation could have wreaked on their lives is truly profound. And I think what the court did today with Justice Vonneman's decision, which was almost entirely unanimous, apart from a technical point raised by Justice Madlanga, was actually saying, you know, the social grant system is so necessary. It's one of the achievements of our constitutional democracy. But unfortunately today, this judgment is not about honoring that. We were brought to this place because of a profound lack of accountability and responsibility from the minister and SASSA in making good on a court judgment that was delivered in 2013. And unfortunately, that's what forced the court to make the truly extraordinary decision that it did today.
And when you go through the judgment, Karen, it's very clear that accountability is top of mind for the Concord judges, but also there's the matter of where do we go from here on for the various parties, the minister, CPS, that no one walks out of this feeling like they have been exonerated of any wrongdoing.
I think what was amazing was that the court stated in one of the paragraphs that it knew that the particular course of action that it was prescribing was actually pushing the limits of its own remedial power. But it said these are exceptional circumstances. And this entire situation brought the nation to a precipice of a national crisis, and therefore we were compelled to act in the way that we did. Remember, courts under the dictates of separation of powers are quite reluctant to get into kind of these situations where government oversight would normally be exercised. But essentially the court is saying with this judgment, you pushed us into a position because you, as the executive, failed to make good on your promises to the South African people. So we have had to step in. Now, what they've said to the minister, which is truly extraordinary, is they've issued what is called a rule nisi, where she has to file an affidavit by the 31st of March explaining why she shouldn't be personally held liable for the legal costs of this case, which is truly extraordinary. And in the ambit of what the Constitutional Court can do, because it's not a lower court, it doesn't really have the potential to hold people in contempt of court. This is the strongest kind of potential punishment that the court could wreak out. But it's also in the way that it's structured this order, said to SASSA and the minister, you need to report back every 3 months to tell us what you're doing, to make sure that someone takes over from CPS. We are exercising our supervisory jurisdiction, which we abandoned in 2015, off the back of you telling us as SASSA that everything was well and good with the world and you were going to be able to continue. We're now intervening. We're exercising that oversight function. Treasury is exercising oversight in terms of the way in which CPS will be paid. We are not going to be held hostage by you, CPS. And, asking also that the Auditor General oversee the potential bidding process as well.
Karen, what is this likely to do, especially on the issue of the separation of powers? There has been a tension between the executive and the judiciary, and it was one of the things that even the SCOPA chair, Themba Godi, had raised, that the courts are now forced in a position where they have to overextend their hand. So going forward in terms of unpacking and analysing today's judgment, are there further reaching implications that this could have, given the precedent-setting nature of this judgment?
What is so unfortunate is that we had that incredible Nkandla judgment, which was really about the president failing to uphold the Constitution and therefore his oath of office in terms of the entire Nkandla scandal. And what is tragic is not the fact that the court is having to exercise the role that it has, constitutionally speaking, to hold the executive and to hold government entities to account. The tragedy is that they've had to do this again and again and again. And what point do we actually ask ourselves whether government is learning any lessons from these experiences? It is one thing to make an irrational decision, as Minister Nathi Nhleko has been found to have made in the appointment of Burning and Tlemeza, in light of the incredibly profound findings about his dishonesty, and now to sort of say, well, I could appeal that. It's a completely different situation where you have a minister who has a judgment against her already, SASSA already against them, and they get legal advice that says urgently go to the Constitutional Court. We can avoid a crisis, we can avoid a drama, we can avoid all these things, and yet they choose not to do so. And when they're asked to explain that to the country's highest court, they say, well, no one made a decision not to tell SASSA. That is truly extraordinary. And it is very disturbing that, there is a suggestion here that there just either isn't respect for rule of law or for proper accountability of the executive within the court structure, or they simply don't care. And that, for all of us, should be a deeply disturbing thought.
And up until today's judgment, the minister has managed to evade or even hide behind SASSA and CPS, and the CEO of SASSA as being mainly responsible for this entire crisis. But now she's not going to be able to escape, given today's judgment. When next are you at court, and what are the kind of things that the minister must then answer?
By the 31st of March, he needs to file an affidavit explaining, in response to the court's assertions that how did you not know about this from May, which is when it was first formally raised as a problem? I mean, you have oversight as a minister, you should have known about it. And then when you knew about it, officially speaking, in October, why did you do nothing to actually take the advice of your lawyers, come to the court and disclose what was happening and avoid this incredibly avoidable crisis?
And let's talk about the payments and the fact that on the 1st of April, can people rest assured that they will have their grants, given the fact that in the last couple of days, we've also had CPS, throwing threats around, saying if this deal is not inked by the end of today, we can't do this. This was on Tuesday or Wednesday already. So where are they right now? They're ready to proceed.
This judgment is so brilliant on so many levels, but one of the most important things that it says is essentially that when CPS took on this business of acting as a distributor of social grants, it became a state institution. And it accepted that in light of the 2012 tender, and it accepted that in the findings of the 2013 judgment. So it is constitutionally mandated to ensure that the payments are made, as is SASSA. And in structuring their order and judgment like that, they didn't, CPS cannot make demands regarding payment. It can't say, well, we won't do this unless you give us X, Y, Z. That's what's so brilliant about the judgment. They've said, if you want a inflation increase, or you're saying that, you have all these expenses, then you must go to Treasury and make a request, and Treasury will handle that. So they've been very careful about not, the court not sort of rubber stamping a thing which says we're going to just give CPS whatever they want because we're being held hostage. Mm-hmm. They've said, no, we're extending the 2012 contract under the terms of that contract, plus you cannot data share the information of grant beneficiaries, plus Treasury has oversight over your expense issues, and by the way, we want to know about all your expenses and the money that you've made out of this at the end of this entire process. So CPS's wings have been quite profoundly clipped by the Constitutional Court, and I saw quite a profound tweet yesterday from Philip de Wet, or Sam Sol actually, saying in response to someone, saying, well, they've said that they can't, that they need this deal done by the end of the day. And he said, Mogoeng is not going to blink. And Mogoeng and the rest of his court didn't blink.
Certainly a story that remains far from over yet, but certainly good news for the recipients of those grants that, in fact, they will go ahead uninterrupted on the 1st of April. Specialist reporter Karen Moore in studio with me. Well, when afternoon news continues in a moment.